Bom dia a todos, meu nome é Leonardo Nemer Caldeira Brant, eu presido o Centro de Direito Internacional com sede em Belo Horizonte. É com muita alegria que eu saúdo a todos os presentes, saúdo igualmente os professores internacionais e nacionais que irão estar conosco durante essas 2 semanas, durante o 16º curso de Direito Internacional. Eu gostaria de dizer que, em primeiro lugar, esse curso foi todo desenhado num novo modelo online. Nós já estamos aí no 16º curso desse gênero. Ele foi totalmente adaptado às novas circunstâncias, o que, de certa forma, permitiu também uma extensão do número de participantes, de professores internacionais e nacionais participantes. Temos este ano 19 grandes nomes do direito internacional que estarão presentes conosco durante essas 2 semanas. Num primeiro momento, portanto, eu gostaria de agradecer a todos os professores que colaboraram conosco, que estarão conosco nesse período, com palestras muito interessantes sobre temas dos mais variados do direito internacional. A todos eles, o meu muito obrigado. Em segundo lugar, saúdo e agradeço também aos alunos, aos estudantes que estão participando neste período de julho, conosco durante essas 2 semanas. O nosso também muito obrigado. Esse é um curso que envolve uma grande equipe do Centro de Direito Internacional, a qual eu tenho o imenso orgulho de colaborar e de presidir. Ele é um curso que pretende trazer para o Brasil e para a nossa América Latina o mesmo modelo de cursos que, de forma quase centenária, já é uma tradição nos países europeus e nas principais universidades do mundo. Portanto, para nós uma grande satisfação que tenhamos ele já há mais de uma década no Brasil. O curso de inverno de Direito Internacional, com toda a sua abrangência e extensão, não seria possível de ser realizado igualmente se não fosse a relevante parceria e a confiança e o apoio da Fundação Konrad Adenauer no Brasil. A ela estendo um caloroso agradecimento e tenho a certeza de que estamos contribuindo juntos para os valores do direito internacional, para os valores dos direitos humanos, para os valores do Estado Democrático de Direito, para os valores da democracia e, com certeza, para a compreensão e construção de um mundo, de um universo internacional mais justo e mais equilibrado. Portanto, agradeço de forma calorosa ao apoio da Fundação Konrad Adenauer no Brasil. Gostaria, portanto, de dar início ao 16º curso de inverno de Direito Internacional, esperando que todos tenhamos 2 semanas de muitas atividades e aprendizado. Um forte abraço a todos.
Good morning, ladies and gentlemen. My name is Marcílio Franca. Good morning, dear students, dear colleagues. On behalf of CEDIN and Professor Leonardo Nemer, and in my personal capacity, I would like to welcome all of you in this session, this lovely Monday morning session, where we have the pleasure and the honor to listen Professor Philippe Gautier, who is going to deliver a presentation about the ICJ and the settlement of international disputes, new challenges. Professor Philippe Gautier is registered greffier of the International Court of Justice in The Hague, Netherlands, and professor of the Catholic University Leuven, Belgium. Previously, he was greffier register in the International Tribunal for the Law of the Sea in Hamburg, Germany, and head of the Treaties Division of the Ministry of Foreign Affairs of Belgium. Dear Professor Gautier, I'm very pleased to welcome you in this session, especially in this occasion, this year, when we celebrate here in Brazil the anniversary of the visit of the Belgian King Albert I and the Queen Elizabeth 100 years ago. That was the first visit of a head of state in Brazil, and is a symbol of the very, very good relations between Brazil and Belgium. Thank you. Thank you very much, Professor Gautier, for attending this invitation. The floor is yours. Thank you very much. Your sound, please. Mic.
Yep. Thank you very much, Professor Marcilio Franca, and thank you for your kind words of introduction. It's a pleasure to be with you, even virtually in a sense. We do understand that the circumstances are dictating this way of processing. At the same time, it's probably excellent for the protection of the environment, not to take too many planes. And it's also a pleasure to say hello to all the students of Belo Horizonte, the university and the center, CEDIN. Thank you for your kind invitation. That's really very kind of you to invite me to address such an audience. And what I would say, my last time and first time in Brazil was 6 years ago. It was in Sao Paulo. At that time, there was a judge at the International Tribunal for the Law of the Sea, Judge Marota Rangel, who was from Sao Paulo. We had a celebration there. And it brings me sweet memories. It's very good to be back in Brazil, even
Thank you very much.
From The Hague. And here it's summer. Those who know The Hague know that sometimes it's rainy, but today we have the sun. So I bring a bit of sun, but I suppose you have plenty of it. What I intend to do is, and I will share with you the screen, and I have prepared a PowerPoint for this purpose. That's the menu. I would like first to say a few words on the peaceful settlement of international disputes. I know I have 60 minutes, because I will try to focus on the really crucial essential points, and thereafter an overview and trends in the jurisprudence and judicial activities of the ICJ, the International Court of Justice. And probably I will not be able to complete this part and the part 3 relating to the contribution of the ICJ to international law will be addressed the day after tomorrow. I need also to add a word of caution. I'm here addressing you more from an academic capacity, I would say. I cannot hide the fact that I'm also a registrar of the ICJ, but I'm not at all representing the court. I want that to be clear. Well, we start, and Professor Marcilio Franca, you referred to 100 years ago. It's exactly where the story started, also with the peaceful settlement of international disputes, or a bit more than that. Because I will bring you back into history for a brief moment, because what happens now is also based on the past. And if you don't understand how the story has developed, it's sometimes difficult to grasp how the peaceful settlement of dispute is articulated. Thus, I will start. I try to move the screen. Well, I found a way. Everything is new in this world. Yes, I take you a bit more than 100 years back to history, because that's, as you know, and you are all very aware of the fact that the Jay Treaty between the USA and United Kingdom, following a war of independence, was really the first time in history that peace, or the peaceful settlement of dispute, was considered as an alternative to war. And it's a very important time. It's at a certain moment, states realized that it would be more costly and it would be more costly to wage a war. It's much better to try to settle a dispute. And J Treaty is named after the former Minister of Foreign Affairs, who was the Chief Justice of United States at that time. I will not detail what was in the J Treaty. You will know that there were some commissions dealing with different categories of disputes: maritime, border, private claims. That's not the point. What was interesting is to see that there were commissions instituted composed of national of states, and if those commissions initially composed of 2 members could not agree, there would be an umpire, a third one, in order to make the difference and to decide. But that was still a continuation of negotiation, in the sense that those persons, the commissioners, were nationals of the states concerned. What I should also mention is that it was not exactly a very quiet story, the fact that this treaty was negotiated. If you see that it was ratified with really a short majority, 20 against 10 among the members of the Senate of the US. It's sometimes a risky choice to try to settle disputes peacefully, but you need to use a specific time, and the circumstances have to be also in place. It's important to keep that in mind. It was just not obvious at that time to make a choice in favor of peaceful settlement. Well, another episode, which is very well known, relates to famous arbitration, Alabama claims. You know that the Alabama was a Confederate Navy vessel, which during the Civil War in the United States between 1861 and 1865 was capturing, sinking a number of vessels. According to the United States, it prolonged the war, the Civil War, and the responsibility, or part of the responsibility for this prolonged hostility, was, according to the US, attributable to United Kingdom, because the Alabama and other sister ships, there were 5 or 6 ships which were engaged in those hostilities. Those vessels were built in the shipyard in the UK, Liverpool. That was the basis of another claim between those 2 superpowers at that time, the UK and USA. But here also, those 2 states didn't want to engage into the use of force, and prudently, given also some specific historical circumstances, they decide to conclude an arbitration treaty, 1871, and to bring the contentious case to an arbitral tribunal. I cannot resist to show you this painting of Manet. That was the destruction of the Alabama off the coast of Cherbourg, because the ship was hosted in Cherbourg in order to make some repair, and thereafter there was this naval fight. I also show that because it was a well-known fact at that time, and public opinion knew about that, and therefore the fact that this story is part of the community life is also important to mention. It was not just among lawyers. The public opinion was involved in this history. And if you visit Geneva, you will also certainly visit the Alabama Arbitration Room, la salle de l'Alabama. Les Genevois are very proud of it. It was a true third-party settlement, the Alabama arbitration, since arbitrators were selected by a number of heads of states, UK, USA, but also Brazil, Italy, and Switzerland. That was a truly international arbitration. If I move a bit quickly, I would reach the Hague Conference, and you know, of course, that there were two conferences in 1899, but also in 1907, and a major difference between the two is the composition. In 1907, there were a number of added countries from South Latin America after accession of independence of a number of countries. That's an important point to mention. The Hague Conference is a very specific time in history. It's where the history of the peaceful settlement of international disputes starts, really. And it's also due to some circumstances. You will, here you know probably that the invitations or the initiative was taken by the Russian Tsar, Nicholas II. Those communications at that time were in French. But that what motivated Nicholas II to launch this initiative, probably to avoid wars, but also because of the costs of acquiring more and more sophisticated armaments. That was also for economic reasons that it was considered that peace was a viable alternative to war. And we are still in the aftermath of the Hague conferences. You know also that the invitations ultimately were addressed by the Queen of the Netherlands, and the conference therefore took place in The Hague. You know also probably that the first conference of The Hague, there are others dealing more for the law, the rules applicable to armed conflict, but that's really the starting point of the Pacific settlement of international disputes. And it's not only recourse to arbitration, which was decided at that time, but also the interest was to give a full gamut of diplomatic means which could be used in order to prevent recourse to force. But at that time, already, and that's the reason I mentioned that, the idea of establishing a permanent court, a true jurisdiction composed of elected judges was in the air. And there were proposals, like from the United States of America. There were very precise proposals. And if you read those proposals, you will see that's more or less the statute of the PCIJ, which was already on paper. But it could not be agreed upon by the participants. Time was not right. And also, a very important point on which there was a disagreement was the way of electing judges. It's always the same issue. The powers or important powers want also to waive a judge, while the other states, on the basis of equality, want also to waive access to the possibility to select, elect, propose, nominate a judge. But that was one of the reasons why this permanent court was not finally set up. But if you look at the Hague Convention, you will see that reference is made on the Permanent Court of Arbitration, and you know that the Permanent Court of Arbitration is not really a court, it's a list of arbitrators, and it's not permanent since these arbitrators are selected for a specific case. That's really more a center of arbitration, which is successful, but it's not yet a permanent court. Also, another bone of contention, another issue was the need to have recourse to a peaceful settlement mechanism. And you see in Article 19, that's what is called a vœu, wishful thinking, if you wish, in the sense that there was no agreement among the participants to declare, to oblige participants to have recourse to a peaceful settlement mechanism in case of a dispute. But what remains is Article 19. It means even if there is no compulsory settlement mechanism in place, nothing prevents states from agreeing among themselves to go for it and to submit their disputes to a third-party adjudicatory mechanism. That's also some principle which is still, we are still operating under this principle of consent-based jurisdiction when it comes to arbitration or a standing court like the International Court of Justice. Well, that's the place where I'm addressing you, the Permanent Court of Arbitration in 1913, but after that, you had the Permanent Court of International Justice. That's the immediate predecessor of the International Court of Justice. And its creation was provided for in the Covenant of the League of Nations, but it was not yet put into place because a statute had to be negotiated, and that was the task of a comité de juristes, committee of jurists, and there was a Brazilian member, Raul Fernandez, also a Belgian one, Baron Descamps, and those jurists were preparing a draft statute which was submitted to the Council of the League for adoption. And I mentioned that because at that time, again, the issue of compulsory mechanism was heavily discussed. The Committee of Jurists was proposing compulsory jurisdiction. That was not accepted by the Council. One legal reason for that was that according to the Covenant, there was a choice to be made, either for diplomatic solution or judicial or arbitral solutions. Therefore, to impose compulsory recourse to the PCIJ would be contrary to this freedom of choice. Well, eventually, and you may read that it's also an idea from a Brazilian lawyer, from Professor Fernandez, you had this brilliant idea of Article 36 in the statute of the PCIJ, which is similar to mutatis mutandis to what is now in the statute of the International Court of Justice. It's the optional declaration. A brilliant mechanism because it gives the possibility to states in advance, before a dispute arises. And everybody knows that once a dispute arises, it becomes very difficult to agree to go for a court arbitration on for a binding mechanism. This is much more wise in anticipation before a problem arises to agree on some mechanism. And you may do that in a unilateral way. And if you do that, all those states which are doing the same are bound together. Whether it's a treaty, that's another question, that's an open issue sometimes among international lawyers, but what is sure is that there is a binding link among those states which go and make this declaration. The system is not new. It was at that time. It's important to keep that in mind when you envisage this mechanism. There is an history. And it was quite successful, I would say, at the time of the PCIJ. The PCIJ delivered 29 judgments, 27 advisory opinions in a brief period of time, between 22 and 40, 1922 and 1940. And at the end of the 30s, there were, according to Chataille-Rosen, 40 states which had made this optional declaration out of 52 states parties to the statute. Yes, that's on the average, it's not a bad situation when it comes to the optional declaration. Well, I now conclude this first part with a few comments. And I mentioned that one element which is very important is this decision to, at a certain time, to consider that the peaceful settlement of dispute is much more interesting, it's much more valuable than recourse to force. And that's really, that sparked the time which came thereafter. But the attraction of the peaceful settlement of international dispute is not only based on this need to avoid armed conflict. It's also, I would say, the only tool in international law to develop rules of international law. What do I mean by that? I would say that international law is intrinsically linked to international jurisprudence. And why so? Because in international law, you don't have a centralized system of governance. Sure, you may have sometimes sanctions adopted by the Security Council, the United Nations Security Council, when it functions, when there is no veto used and there is a majority for it. But if you put that aside, there is no real centralized system. And that means that if there is a breach of international law, the only way to obtain remedy is to bring the matter to a judge. And it's only if the matter is brought before an international court or tribunal that the rule of law will be kept, preserved. Otherwise, it will fade away. Does any of you see the history and development of international law is always linked to the development of jurisprudence? But bon, I don't want to convince you of that, but I think that's a very important element to keep in mind. Now, to complete this first part on the international peaceful settlement of dispute, a few words to on some basic principles of or notions. A dispute. You know that there is this celebrated definition given in the Mavromatis Palestine concessions case. That's the PCIJ, because we are still inheriting from those decisions of other courts, of the predecessor, even if there is no rule of precedent in international law. But you see that the definition is repeated. It's a disagreement on a point of law or fact, not only law, also fact, a conflict of legal views or of interests, not only rights and obligation, interests. It's a very broad definition, I would say. It has also to be opposed by the other. That means at least some awareness. You see, it's not with the Marshall Island case that this notion of opposition of views has arisen. It was already in the 60s. It's not a new condition, I would say. A couple of points to develop this. I mentioned it's a very broad definition, but at the same time, it's on the basis of a particular case. And if you look at the compromissory clause at that time in the mandate on Palestine, you will see that it relates to the interpretation or the application of the mandate. Because it's a bit different than just a definition as broad as any legal issue, any point of fact. It was relating to a treaty. That also should be kept in mind. I indicated that there should be an opposition of views. I refer to the definition given in 1962 by the ICJ. I also explained that the decision of 2016 in Marshall Islands case is not completely new. I mentioned that because there are a number of legal writings which have been devoted to this case. But it's quite normal, I would say, that if there is a dispute, the respondent is at least aware of it. Sure, if the respondent claims that it was not aware, that's another thing, but objectively, there should be an opposition of view, and for that, there should be at least some awareness. Another element relating to the notion of dispute is the fact that the dispute should not be moot. In the nuclear test case, that was the reason why the court didn't pursue the case. Well, there also it was a narrow majority, and some judges considered that actually the case was not, or the dispute was not moot, because there was still a possibility to render a decision on this issue, but wisely, probably, the court decided that there was no real dispute since the applicant got what it wanted. And in the beautiful words of the court, while judicial settlement may provide a path to international harmony in circumstances of conflict, it is nonetheless true that the needless continuance of litigation is an obstacle to such harmony. Well, here I will be brief in trying to capture the notion of dispute, is the fact that sometimes parties to the dispute are not exactly the same as the parties to proceedings before the court or an international court or tribunal, in the sense that the court may be prevented from rendering a judgment if it implies that the court should decide on a case involving a state which is not party to the proceedings because it has not accepted the jurisdiction of the court. And that's exactly the monetary gold jurisprudence. In this particular case, Italy brought the case before the court to claim that it had a better title to get the gold, which was removed from Rome, stolen by the Germans in 1943, a better title than the United Kingdom, because the idea was to use this amount of gold as a compensation for United Kingdom after the Corfu Channel case, because everything is linked. But Italy made a claim because it was the nationalization of companies by Albania. But to deal with this issue, to see whether Italy had a better claim than the UK against Albania, there was a need to determine whether this nationalization of Italian companies was lawful or not. But in this case, Albania had not accepted the jurisdiction of the court. Therefore, there was no possibility for the court to enter into this determination. And it's basically a similar situation which happened in the case of East Timor, a case on which also the legal doctrine is not unanimous. But if there are questions, I may answer to that later. I will not spend too much time on that. Of course, the peaceful settlement of international dispute is based on basic principles of international law. The fact that if there is a dispute between countries, the only natural court is an international court. You cannot subject a state to the court of a municipal court of a state, for example, in principle. And also, it's an alternative to the use of force, and therefore the use of force is prohibited since the Charter of the United Nations, or even before, but we will not enter into this discussion. And there is this principle of obligation to settle disputes peacefully. Well, the obligation to settle disputes peacefully doesn't mean that a state has to enter into negotiation whenever there is a dispute which arises. There are disputes which go on for decades. But what is part of the obligation is that if there is a risk of peace and security, that should be settled. This is the obligation to settle disputes doesn't mean that all disputes have to be solved. There are territorial disputes which are there for 100 years. They are still there, but they are not posing a risk for peace and security. That's not the point. What is important is that whenever there is a risk for peace and security, there is a duty to avoid use of force and to try to seek a solution through diplomatic means or judicial mechanism, which are also peaceful means. I mentioned that there is no general obligation to negotiate as such whenever a dispute, but sometimes there are. If you look at the law of the sea, UNCLOS 82, UNCLOS Convention, you see that in some provisions, here Article 74 of UNCLOS, there is an obligation to negotiate. When there is a need to delimit maritime space between opposite or between states with opposite or adjacent coast, there should be there some negotiations, but that's on the basis of specific obligations. You know also, to complete the picture, that there is no prior negotiation which are required before bringing the matter to a court. There is no need to negotiate except if it's written down in a treaty, the treaty you use to bring the matter to the court, for example. There you may have the obligation to exhaust diplomatic means before bringing the dispute to a court. But it's clear in customary law that doesn't exist. Sure, the respondent has to be aware that there is a dispute, and a dispute means an opposition of views, but it doesn't mean that you need to negotiate. Judicial settlement is a peaceful mechanism, and therefore it may be. That being said, in a number of situations, you need to negotiate because it's set out in treaties which are binding upon you, and it's also the basis for action and bringing the matter before an international court. I already referred to this Mavromatis-Palestine concession case. There was also a need to negotiate in this particular instance. And I refer to that because that's another dose. When you will read this slide with a bit more time, you will discover that this pronouncement has been repeated once and again, time and again, in a number of pronouncements by courts, international courts, or arbitral tribunals. What is important is this objective assessment, in a sense. The court has to assess whether there was a possibility to settle the dispute through negotiations. And you have different formulations you may come across in international practice. On the slide in front of you, you have two different cases. If it was not possible to settle the dispute through diplomatic mechanism, that's more an objective assessment, whether rationally, reasonably, it was possible. But in other instances, you see that the opinion of the parties is also part of the equation. Thus, you need to adopt, as a court, a more subjective approach to see whether, on the basis of the conduct, the opinions expressed by the parties, their declarations, there was a possibility to settle the dispute through negotiation when it is required, of course. Just also to complete, and before moving to the International Court of Justice proper, a few words to a general issue. That's access to jurisdiction. And it's linked to the fact that, as I have already indicated, there is no general obligation to bring the matter to a court. There is no compulsory jurisdiction of the International Court of Justice. It's consent-based jurisdiction. And rightly so, probably. States have to agree. But that doesn't mean that they have to agree on the spot after the dispute has arisen. And I've already mentioned that to you. It's always difficult. If you ask lawyers involved in litigation, I'm sure they will all explain that there is always one state which is more demanding than the other, or which is wishing to bring the matter to a court. The prospective respondent may not be so interested. This special agreement is, of course, the preferred way, because you may explain clearly what is the dispute. You define together the questions which will be submitted to the court, and the court will have to answer those questions and not others. You keep the matter into your hands, and it's probably better. It's the preferred option. But in practice, if you look at figures, statistics, you will see that there is a small percentage of cases which are submitted on the basis of special agreements. It doesn't mean that the consent is not there. The consent is always required, but it may be there before there is a dispute, through compromissory clause in a treaty, like UNCLOS. That's unprecedented. The United Convention on the Law of the Sea, with Article 287, 288, which gives the possibility for all parties to the convention to bring the matter to arbitration, ICJ, or ICLOS. That's a brilliant finding by those who drafted this convention, but it's consent-based. It's built in the treaty. You have also a number of cases which have been submitted to the court on the basis of clause contained in other treaties, like the optional protocol to the Vienna Convention on diplomatic relations or consular relations, or human rights treaties, or the Convention Against Genocide. You have a certain number of conventions containing those compulsory mechanisms, and they are used in a number of situations. There are also agreements for the settlement of disputes. The Pact of Bogota is really brilliant idea, 48. And it gives the possibility, after exhausting diplomatic ways, to be able to bring the matter to a court, to the International Court of Justice. There is something similar for Europe, that's the European Convention of 57, but not used as much as the Pact of Bogota. There is no such regional convention, I would say, and here I am really speaking on my personal name, but it would be interesting to have such regional convention in other regions, in Africa, in Asia, in favor of jurisdiction like the International Court of Justice. And you have the system of optional declaration. Oh, there is a mistake on the slides, and I feel sorry for that. It should read declaration. It will be corrected. I already referred to the optional declarations under Article 36, paragraph 2 of the Statute of the ICJ. I could also add the declarations under Article 287 of UNCLOS. It's also a possibility to use the same mechanism in order to give jurisdiction to the court. What should I say to conclude? Well, before moving to the ICJ, I would like to say that, of course, I put the stress on the role of international courts and tribunals in the development of international law. At the same time, I am very well aware that judges are not always the solution. And it's true that to deal with new challenges, current challenge like when it comes to the protection of the environment, political solutions negotiated among states are the way forward. Judges are settling a dispute in a particular case, but the jurisprudence may nevertheless contribute to the development of international law. Another point I would like to mention to complete this first part is to say that nothing should be taken for granted, in the sense that you have to realize that recourse to international court, to the peaceful settlement of international justice, is the result of an history, and it's also based on really persons who have promoted, leading persons who have promoted this solution, the role of learned societies, of NGOs, of prominent personalities is not to be underestimated. If you look at how the peace conference of The Hague 100 years ago or 120 years ago have been to a certain extent a success. It's not only because of international lawyers or heads of states or diplomats. It's because of public opinion. There were declarations, resolutions adopted by parliament, national parliament in Latin American countries, in Europe, Italy, Belgium, Brazil, in favor of the peaceful settlement of international justice. It's not just something which is invented by international lawyers. It's because of the strong support of public opinion, NGOs, that this may continue. And that's the reason I mentioned that nothing is to be taken for granted. It's because also of the new generation, that this system may go ahead. This system needs to be supported, protected, promoted. That's what I wanted to say to conclude. Now, I would say 20 minutes. I'm looking at Professor Marsilio Franca, to try to advance with my presentation of the ICJ. And what I want first is to give you an overview, to have the basic tools, and thereafter to look at really the trends and look at statistics, in particular with respect to cases and proceedings which have been brought before the court. You know that contrary to the Permanent Court of International Justice, which was not an organ of the League of Nations, it was created by a separate protocol containing the statute. The ICJ is the principal judicial organ of the United Nations. The statute of the court is in the UN Charter, which entered into force on 24 October 45, and the first election of the judges of the court took place in February 46. That's the reason why every February, every 3 years, when there is a partial renewal of the court, it's take place in February. The inaugural public sitting took place on 18 April 1946, and you will immediately realize that it's not 45, it's 46. This we are celebrating this year the 75th anniversary of the UN. This we are also part of the UN, but next year there will be the 75th anniversary of the ICJ proper. And there will be a celebration, I don't think on the 18th of April next year, which is a Sunday, but probably the 19th of April. You are all welcome if the circumstances are a bit different. The 75th anniversary of the ICJ, that's something important to celebrate. You know that the first case was the Corfu Channel case between the UK and Albania, and the first decision was rendered in 48. That was the Corfu Channel. A few words concerning the composition. There are 15 judges, independent judges, and they are elected from among persons of high moral character who possess the qualifications required in their respective countries for appointment to the highest judicial office, or are jurisconsulates of recognized competence in international. This competence-based election. And if you look at the composition, classically, you have judges who have served in the diplomatic service and with great experience in international law through practice, or with more an academic background, professor, but also with, of course, we've been exposed to international law and to the international practice. It's the same system of election than at the time of the PCIJ. You need to be elected by two organs, the Assembly and the Council. That's very important. And I mentioned that because it shows that there is affiliation, in a sense. In order to be nominated, a candidate has to be nominated by the national group of states member or party to the Hague Convention, which set up the Permanent Court of Arbitration. There is a tradition from the Hague Conference to the ICJ. That's what I wanted to underline. I also refer to this mechanism, which was never used. It was nearly used a couple of years ago when there was a balance between the candidate from India and the United Kingdom, but there was no use of this mechanism when there are candidates which do not collect a majority in both the General Assembly and the Security Council. And there is this mechanism. I mentioned that because this precise mechanism was invented at the time of the PCIJ. It was not at that time placed in the statute, but it was for the first time put into place during the first election of judges of the PCIJ, when there was a candidate from Belgium, Baron Descamps, and a candidate from Chile. Those two candidates were not getting the support of both organs, and this system was put into place, this mixed commission, joint commission. And finally, there was a candidate, a judge from Denmark, who was selected. It's perhaps a detail, but you will know that I have some interest for history, at least when it shows that there is a continuity between past and present. Well, composition, another touch, another added element is the fact that judges have to be independent, and integrity is also part of their function, and it's built in the statute. They have also to recuse themselves if before, for example, when they were legal advisor or lawyers, they were involved in a case which is now before the court. And it has happened since the time of the PCIJ and nowadays also. That's an important part. There are some practice direction reinforcing that. I will not insist on it. No, all the judges, 15 members, cannot have the same nationality. They have to be from different states. But at the same time, you know that there is this institution of judges ad hoc. It means that if a state is participating in proceedings before the court and there is no judge of its nationality, it's from the days of arbitral proceedings, I would say, from the early days where you recall the Jay Treaty, where commissioners were nationals of the states concerned. There is this idea that there is sometimes a need to have a member of the court, even if he or she is independent, can understand arguments or legal provisions in municipal law of the state concerned. There is the possibility to choose a judge as judge ad hoc, who will sit in complete equality with the 15 judges and who may decide on the case for this particular case. Sometimes you may have two judges of the same nationality because one is ad hoc and another one is an elected judge. You may have also the possibility of a decision adopted by the court or by one of its chambers, but usually I would say in the large majority of cases, parties prefer to bring the matter to the full court and not to one of its chambers. In any event, it's available. Parties may decide. It's always based on consent. The competence of the court, it's important to underline, is general. All matters may be submitted to the court. And if you look at the charter, you will see that it means that there is a contentious jurisdiction, disputes between states, only states, and the possibility for international organizations which have been authorized to do so or which are authorized under the charter, the United Nations, of course, but also the specialized institutions to seek a non-binding advisory jurisdiction on a legal matter. As I indicated, for contentious proceedings, only states and states parties to the present statute. And you will tell me that member states to the UN are parties to the charter. The statute is an annex to the charter, therefore there is no problem. Yes, there is a possibility for a state which is or was not a member, like Switzerland in the past, to become a party to the statute if it accepts certain obligations regarding the peaceful settlement of international disputes indicated in the Charter. That's a possibility. There is also even a possibility for a state which is not party to the statute to become party to a case. But for that, that state has to also make a declaration accepting the jurisdiction of the court, generally or for a particular case, through a declaration which has to conform with the conditions announced by the Security Council. There were also different such declarations made in the past, like Cambodia, Federal Republic of Germany at a certain point in time, Albania, Italy, but nowadays the only declaration which was made in 2018 was by the State of Palestine, but that's a point under disagreement in a case which has been brought before the court between Palestine and United States of America, and United States has mentioned that they've objected to that and there is no treaty link between the two entities. But that's the case sub judice. This, I will not enter into any details on that. As indicated, only states may be parties to contentious proceedings before the court. It doesn't mean that international organizations may not be solicited to provide some information. I refer to Article 34 for that purpose. There is a possibility for organizations to be requested or even on their own initiative to provide information if, of course, they have a competence related to the subject matter of the case before the court. I mentioned competence. I have to refer to Article 36 of the statute. And Article 36 of the statute has this paragraph 2, which refers to the possibility to recognize the jurisdiction of the court through a declaration. That's the optional declaration I refer to. For the time being, there are 74 states which have made such a declaration. It has to be compared with the 193 member states of the UN. A large majority of those declarations contain reservation. It may be. It's the consent-based jurisdiction, therefore states may decide to limit the acceptance of the jurisdiction of the court, and that's an important point whenever there is a case brought before the International Court of Justice, an important point to consider. On the slides, I put simply 2 samples. It's only just as a sample. What is important is in this example is what is under A. Any dispute in regard to which the parties thereto have agreed or shall agree to have recourse to some other method of peaceful settlement. It's the same also made by the United Kingdom in 2017. I mentioned that because it played an important role in a recent decision of the court. That's the decision in Somalia versus Kenya, where in this particular case, Kenya had made a similar reservation. That means that Kenya recognized the competence of the court, except if it had agreed to have recourse to some other method of the settlement of dispute. And of course, UNCLOS contains a specific mechanism for the settlement of maritime boundary disputes and other disputes related to the Convention. Therefore, the lawyers for Kenya mentioned, but this reservation should apply, and therefore that's the mechanism under UNCLOS which would have to be followed, and if so, it would be because in this particular case, it would be arbitration, which is the residual mechanism under UNCLOS. Well, there is a specific provision in UNCLOS, Article 282, which is organizing some choice of forum, because it indicates that parties to UNCLOS, which have agreed to Article 287 and to a specific mechanism for the settlement of disputes, if those states have agreed through a general, regional, bilateral agreement or otherwise, and otherwise, if you look at the travaux préparatoires, refers expressly to the optional declaration. If they have conferred jurisdiction through optional declarations to the ICJ, well, that will prevail upon the mechanism under which is contained in UNCLOS. That's something the court was faced with. There was some kind of circular situation, because UNCLOS refers to the optional declarations, and the optional declarations contain a reservation, so-called reservation, referring to UNCLOS. It doesn't stop in a sense. But as I have indicated, this kind of standing reservation limitation, the fact that you accept the jurisdiction of the court, except if you agree for another mechanism, that's standard in more than 50% of all the declarations which have been made. And the court, when it had to deal with this situation, focus on Article 282, which contain, in its view, a clear language. Article 282 is giving preference to the optional declaration. Therefore, there is no reason to opt out of this system, and this system applies in lieu of the procedure contained in UNCLOS. Well, it was addressed in a number of writings, this position of the court. Sometimes lawyers were not in agreement. What is important is the fact that there was at least the forum selected by the parties through optional declaration, which declared itself competent. That's something which is positive in a sense. Otherwise, it would be unwise to leave the matter to another forum without being certain that this other forum would declare itself competent, for example. And ultimately, what matters is not this, I would say, this artificial construction based on those renvois contained in UNCLOS or in this optional declaration, but the fact that justice is done. Well, I will probably stop here, or I will go on. No, I think just if you allow me with still 5 minutes maximum.
Okay, that's perfect.
Yeah.
5 minutes. Okay.
No more. I can go on for 5 minutes or a bit more after 30 if there is a need. But just in a nutshell, what is on the slide reflects what I have already explained to you as far as the first bullet is concerned. In order to bring a matter to the court, either there will be a special agreement and you need to notify that, or an application. An application means unilateral application. That means that there is a pre-existing consent given. That's it. In the application, you need to designate agents. Agents are really important personality. Those are the agent representing the state. They may take commitments on behalf of the states they are representing. Usually they will be officials of the state in 95% of the case, but sometimes they may be international lawyers. That happen in the practice. You know certainly that the procedure is based on a couple of principles. There are written proceedings followed by oral proceedings, and they are in the course of written proceedings you will have at least two sets of pleadings, a memorial and a counter memorial by the applicant, a counter memorial by the respondent, at least if the case has been instituted on the basis of an application. And if the court decides it's useful, there is a second set of pleadings, the reply rejoinder. You may realize that in important cases, and all cases are important for states, states will be tempted to bring not only memorial but also reply, because it's only through the counter memorial that they will discover some arguments. They want also to articulate fully their case, and they want to take advantage of this reply. It's quite common. Oral proceedings, usually it's for 1 week, no, because the court is trying to advance things, and there is no more oral proceeding expanding for 3 weeks. Usually it's 1 week, and there is also a possibility for parties to call witnesses and experts during those oral proceedings. It's followed by deliberations of the court, and a specific feature of the court is written down in the resolution on internal judicial practice. It's the fact that every judge will prepare, if it's a case on the merits, will prepare a note summarizing her view on the case, and it will start with by reverse order of seniority. The younger judge or the judge who joined the court at the later stage will take the floor first. On the basis of the majority, which at that time does exist, a drafting committee, usually 3, the president and 2 other judges selected by the court, and the voting will only intervene at the end. But you need to vote, you cannot abstain. That's the specific feature of an international judge, no abstention. You have to take a position. The decision will be unanimously adopted or by X vote against X vote, and the name of the judges will be indicated. Judges may also append to the text of the decision the text of their opinions or declarations. Declaration is normally a brief statement of the position. It may be a judge in favor of the majority or a dissident judge, if I may use this expression. Dissenting would be proper. And opinions that may be dissenting opinions for a judge who has voted against, or a separate opinion for a judge who has voted in favor but wants to explain more precisely how she reached this decision, and perhaps there may be some nuance the judge concerned wants to express. That's very important, and when you read those opinions and declarations, sometimes it brings some light on the deliberations, but without disclosing the secrecy of deliberation. But you may see that there was a divergence, or there was different opinions among the judges, and that may contribute to the better understanding of the decision. Well, I thought I could still go on with my statistical data, but that will be next time. Thus, I will speak to you on really an overview or the new trends and challenges the court is facing, and I will devote my time between that and also some overview of the contribution of the court. I will have 60 minutes. I will concentrate certainly on the protection of the environment, but I will address 2-3 other matters. Well, thank you for your attention. It's not so easy to interact without seeing you, but I hope you have enjoyed this lecture, and nevertheless, I stand ready to answer your questions. Thank you.
Thank you, Professor. It was really interesting. Thank you very much for such an insightful and beautiful presentation, full of works of art and interesting case. I'm especially happy because many of the cases you mentioned had the participation of Brazilian judges like Epitácio Pessoa in the old Permanent Court of International Justice. So, Professor Gautier, we got some questions. Let me read here some of the questions we got. First of all, we have here a question from a student called Gustavo Tanus. Professor Gautier, you mentioned some of the new challenges arising in the settlement of international disputes. What is your view on the settlement of disputes regarding restitution of cultural objects?
How do we proceed? Do we?
We have 15 minutes. I can read 2 questions if you prefer. 2. You can comment. The second question comes from Maurus Volensak. Dear Professor Gautier, could you please comment on the difference between the international procedures beyond the written texts at the ITLOS and the ICJs, with a particular focus on the case load?
Okay. For the issues or cases concerning restitution of cultural object, the issue relates to, I would say, access to jurisdiction. It's always a possibility to bring such a matter to a court if there is an obligation to do so. And also there are rules which exist in the matter. You have, even for a cultural object on the sea, you have the UNESCO convention in this matter, and it gives also shape to obligations which are contained in UNCLOS, which are very limited. But as I said, I would mention that the main issue in this context is an obligation to bring the matter to a court, ICJ or another court, or an arbitral tribunal, if the parties so wish. But I am not so aware of case, except if you take the case concerning Germany and this painting, which was the subject of a case instituted by Liechtenstein. But that was, the court could not enter into the merits of the case because of limitations contained in the European Convention of 57, if my memory serves me right, because it was related to confiscation which happened after the Second World War, and the painting was belonging to what was considered as German interest. And the court at that time considered that since the European Convention of 57 contains a clause which is not retroactive, it doesn't give competence for what happened before, the court could not deal this. The court declared itself incompetent. That's the only case but we could say that, to make a connection with the Alabama ship, I told you it was sung off the coast of Cherbourg in France. And you may know that in the 80s, the wreck of the Alabama was found. And it was considered as a sanctuary because, you know, for some Navy forces, whenever a naval vessel has disappeared, has sunk, it's still parcel of sovereignty, and therefore there is still to be protected. And there was a treaty concluded between France and United States for the preservation of the wreck of the Alabama. That's not the case before a court, but it shows that those matters may, if there is no cooperation among the states, it may lead to a dispute. That's all what I would say at this stage. Regarding the other question, that could be the subject of another lecture, but I will try to be brief regarding the rules of the court. And if you compare with the rules of ITLOS, there are similarities, I would say 85%. It's more or less the same approach, but there are a number of differences. But you need really to analyze the rules in order to look at those differences. For example, time limits. Time limits are quite different when you look at preliminary objections. That's the possibility for the respondent. Very often, it could be the applicant. Italy objected to the competence of the court in the monetary gold case, even if it institute proceedings, but normally it's the respondent, and the respondent may do so before the court. It's during the period of time given to the applicant to file its memorial. It can be 6 months, 1 year. Before ITLOS, it's 3 months, 90 days. This is shorter. The idea was when the rules were negotiated to be efficient and to give more time. But at the same time, it's true that it's not always so easy for a respondent to articulate fully its position only on the basis of the application. The application is sometimes very brief. That's just one example. The written note I referred to during the deliberation is something which is not the practice of the ITLOS. It doesn't mean that there are no written notes, but it's not the part of the usual setup. That's otherwise, there are also procedures a bit different because before ITLOS, and in particular the chamber for the settlement of disputes related to the deep seabed mining area, you may have private individuals or companies, natural persons appearing. There are specific rules there which you don't have before the court because there only states may appear. That just in a nutshell, one or two differences, but I would say as a whole, 85% is similar.
So, okay, thank you very much. Just, I think we have time for the last question. Thais Albuquerque, a student called Thais Albuquerque, asked you, Professor, Professor Gautier, could China be taken to ICJ over COVID-19 pandemic? It's not easy to answer.
Well, that's a very sensitive issue. I mean, you may replace the name of the country with another one and the subject matter with another one. My answer would be the same, in the sense that in this respect, you need a dispute. You need consent. You need access to jurisdiction. It's a basic tool, and it's something we need also to recall. states are not bringing a claim like that out of the blue. It's because they pursue some interest, which may be interest of the international community. There may be sometimes cases brought before a court by a particular state, but in order to protect common goods, that's not prohibited. But there's always an interest in order, in French there is sans intérêt, pas d'action. Without interest, without something which moves you, you don't act. And therefore, you need to first have an interest, but also to claim that there is a breach of an international obligation. And this obligation may be customary law, maybe in a treaty, maybe the duty not to alert other states, the obligation to act with due diligence, which is not an obligation of result, it's an obligation to take care, to avoid that harm would cause to the territory of another state, for example. That's something you may claim that. No, you need certainly to make a representation to the potential respondent, or to make it clear that you consider that there is a breach of an international obligation, and the respondent should be made aware of that. Doesn't mean that there is a need to negotiate. And after that, you need to find a way to bring this matter before the international court. It means that you, as applicant, and the respondent should have agreed in a treaty, through optional declarations, that a dispute involving those two states could be moved before the international court. Because that's the ingredients. Without that, you may think of any dispute you may think of, but without those basic tools, that's the reality in dispute settlement, and very often that's what is missing. That's the access to the jurisdiction. That's the importance of promoting commitments, obligations, in order to settle disputes. And for example, you may see that with the Pact of Bogota, one of the member has decided to withdraw. That's something probably which need to be reflected on, because without adhesion, without the consent of all states parties, there is a step back in the promotion of peace and international justice.
Okay, thank you very much, Professor Gautier. If you don't mind, I would propose to stop here this session. It's 9:30. I know that your agenda is always busy. Thank you again for your availability for this wonderful conference, and see you again Wednesday. Yes, after tomorrow, at noon, 12 o'clock here in Brazil.
Yep.
Brazilian
that
time.
Will be 5 for me. There's a different time, but probably more convenient than this morning. It was a bit early for you.
No,
sorry
it
for that.
was good. Wonderful.
Okay.
For us, it's perfect. So
it was a pleasure to see you, and see you the day after tomorrow.
Day after tomorrow. See you. Thank you again. Bye-bye.
Bye-bye.